All right. I just want to thank everybody for being here and welcome to our meeting on the Standing Committee of Economic Development and Environment. We want to welcome the Clecho government and look forward to hearing your thoughts, of course, and the concerns that the Clecho government has regarding the bills that are before us under review. And so maybe what we'll do, Grand Chief, if you care to open today's proceedings with a bit of a prayer.
We'll just get into the presentations, and then the presentation will speak for itself. So the first to present will be Chief Alphonse Biciza from Wati.
Okay, thank you, Grand Chief. Thank you, Grand Chief. No, I was just asking if you wouldn't mind leading us in an opening prayer.
We'll just remain sitting. Say no sing. Go right down there. The test 18. The take on the in. The who said the good thing you are. And you wicked. The take who think you who and the good in that so good on the D. So let's say DC. The cow zani the cow sinezin go get ku go get gintere singu de sun cow. Yes, our Creator, we're here asking for your help, your guidance. We are pitiful in some ways, in a lot of ways. We're here to speak on behalf of our people and to help each other to go forward. We need your help, Father in heaven. Things are around us, lots of death in our community, in our regions, and everywhere else. That's why keep our hearts strong and we listen to each other good. You make that happen, Father in heaven. Amen.
Thank you, Grand Chief. Thank you for your prayer. I want to, for the record, ask members to please introduce themselves, and I'll start with the member that is on our joining us by webcast today.
Good afternoon, RJ Simpson, the MLA for Hay River North. I have some business to attend to in Hay River, so that's why I'm here for the day. But I want to thank you for joining us. I'm going to shut my camera off while I'm not speaking because I know it might be a bit of a distraction to have a giant floating head behind the chair. But thank you for joining us.
Thank you, and I'll start with my far left.
Good afternoon, everybody. Thanks for coming. It's good to see folks from the Clecho, especially the leadership. I know you've had a tough week and tough few weeks, actually. So we're here to work with you and support the work that you do, and you're showing a good example around the territory and in our country. So once again, welcome.
Kieran Tester, member for Cam Lake. I appreciate you making the time. This is a rescheduling of our previous commitment for Betcherco, and we appreciate that you've joined us here today. Thank you.
Welcome, Clecho government leaders and staff here. We look forward to your presentation, and my name is Danny McNeely from DeSatu. Thank you.
Kevin O'Reilly, Frame Lake, Massey for.
Thank you. My name is Corey Van Thine, MLA for Yellowknife North, and also the chair of the Standing Committee on Economic Development and Environment. We also have with us today from our research department, Kathleen Kanoush, and also from our clerk's department, or from the clerk's office, is Glenn Rutland. And so today, the Standing Committee on Economic Development and Environment is holding a hearing on Bill 34, Mineral Resources Act, Bill 36, an act to amend the Petroleum Resources Act, and Bill 37, an act to amend the Oil and Gas Operations Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the Minister, given first and second reading in the Legislative Assembly, and then referred to this Standing Committee for review. Legislation is typically brought forward by Cabinet and is reviewed by Standing Committee. The members of this committee are responsible for holding the government to account, and one of the ways we do this is by making sure that proposed laws are supported by the people of the Northwest Territories. It is our responsibility to consult with residents on what they like or don't like about the bills. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which we will then report back to our colleagues in the Assembly. The Standing Committee held several public hearings on these bills, including Yellowknife, Inuvik, Norman Wells. We will report back to the Legislative Assembly on the proposed legislation during the upcoming August sitting. I wish to briefly just describe the intent of these bills. Bill 34, Mineral Resources Act, proposes to establish new legislation that will guide how mining and mineral exploration and production will happen in the NWT, require engaging Indigenous governments and organizations, including on where no mineral development will be allowed and where it will be encouraged, require new benefit agreements for Indigenous governments and organizations for mines of a certain size, and set royalty rates based on how much mines produce. Bill 36, an act to amend the Petroleum Resources Act, proposes to change the existing legislation by requiring public notice of activities related to petroleum development under this act, including some licenses that are issued, changes how a significant discovery license will be issued, increasing public representation on the Environmental Studies Management Board. More information about the Environmental Studies Management Board will be made public. Also, more information received by the minister and regulator will be made public. Then we have Bill 37, an act to amend the Oil and Gas Operations Act, proposes to change the existing legislation by giving the regulator more ability to issue guidelines and interpretation notes to industry. The regulator can hold public hearings. Minister has to table an annual report on the regulator's activities. More information has to be made public about wells, and makes rules more clear on financial responsibility for wells. There are copies of the bills and plain language materials on the side table, and I know that you've already helped yourselves to these. So one final piece of housekeeping, and that is, please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media, which they are today. So thank you, everyone, for your patience in allowing this introduction. And with members' agreement, we can now open the floor to comments from the public. Do members agree? Agree? Thank you. And so it's my understanding that we're going to start with opening comments from Chief Nitsitsa. So Chief Nitsitsa, I turn it over to you, and just for your information, no one has to touch any of the buttons. Our technician behind the glass knows that just through exchange of conversation with the chair when to change the mics. So with that, Chief Nitsitsa, I turn it over to you.
Thank you, sir. Thank you for the opportunity. First of all, I'd just like to introduce the group we have here. On my right is Grand Chief George McKenzie and our senior advisor, Zabi Nivet. The three of us will speak. I'll speak first, and then Zabi and a final comment will be made by Grand Chief McKenzie. In the back here, we have Chief Clifford Daniel from Bichako, and we have our legal counsel, Paul Bashon, and we have David Widowin from Gamity, the chief, and also Chief Charlie Football from Wikwiti. So with that, I want to thank you to the committee members for taking the time to hear from us today. I thank you for your flexibility in setting this meeting. We are here to speak to the committee about the important new law that the government of Northwest Territory is considering, and provide some response to some of the issues that we have heard discussed during our hearing, or rather your hearing. First, I will make some general comments about the bill itself and how the bill fits together with our Clinchon Agreement. After that, we will address the process followed to draft the bill as well as our concerns and expectations surrounding future processes to develop regulations and amendments. Finally, Grand Chief George McKenzie will make concluding remarks. We have carefully studied the bill, and the Clinton government supported, subject to our comments in this presentation and our written submission, which the committee has already received. Clinton government appreciates the collaborative and consequential approach taken by its partners in government of Northwest Territories and other Indigenous government. The most important issue for Clinton government is assuring that the bill and all the laws in Northwest Territory respect our agreement, respect our rights, and respect the processes and commitments set out in Clinton Agreement. The Clinton Agreement is a vital document for Clinton people. It sets out our rights and jurisdiction on Clinton lands and throughout the traditional territory. Protecting the environment while promoting responsible development and use of resources is the concern of all responsible government in the North, and it's very important to us. The Mineral Resource Act bill. This bill addresses a very important issue, how non-renewable resources will be managed here in Mufigad and Inkle and throughout the Northwest Territory. The management of our non-renewable resources is a matter of great concern for Clinton government and for all Clinton people. Clinton government strongly support responsible mineral development, but must also manage this serious environmental, social, and cultural impact on our people. The Mineral Resource Act bill plays a key role in fulfilling treaty commitments to address those impacts. In particular, the provision that deal with notice requirements and benefits agreements with Indigenous governments are extremely important. These sections of the bills are the result of very deliberate compromises that were reached in discussion between GNWT and Indigenous government organizations. They are critical to success of Mineral Resource Act. Without these sections in largely the form they are in today, Clinton government would not be able to support the Mineral Resource Act. Merci, Mr. Chair.
Thank you, Chief Nitsitsa, for your comments. Very much appreciated. Now at this time, I'll turn it over to Mr. Nevitt.
Okay, thank you, Mr. Chair, committee members, and thank you to the Grand Chief and Chiefs for giving me the authority to speak today on the Mineral Resources Act. Just to clarify, our comments today will be confined to the Mineral Resources Act. We don't have any comments on the other two acts that are before you. So today I'll speak about the process that was used to develop the bill, as well as concerns and expectations respecting future processes and amendments. As you're aware, the bills were developed through technical working groups and subcommittees that were formed as collaborative, cooperative, government-to-government bodies under the guidance of the Intergovernmental Council. Throughout this process, ITI provided us draft copies of policy positions, draft discussion papers, and drafts of the bill itself. And we were provided those through the engagement and consultation process before their introduction to the Legislative Assembly. Through our membership on these working groups and subcommittees, we worked with ITI to develop a draft bill over many meetings over the course of more than a year. Ultimately, Clinton government, Indigenous governments, and the GNWT have developed a bill that everyone felt they could support. We'd like to just commend the ITI reps who participated in the working groups and worked collaboratively with Indigenous government partners. Their hard work in creating creative solutions has resulted in a draft bill that we could all be proud of and support. The committee has recently heard submissions recommending changes to Part 5. Such changes would affect the delicate and complex negotiation of Bill 34. Any amendment that would alter the substance of Part 5 would likely not just be minor or technical in nature, but could easily snowball into further and broader revisions that would take away the very spirit and intent of that section as it was drafted. Section 52 is an important example of the balance that is necessary to earn the support of all those who develop this bill. Subsection 52(1) requires proponents to negotiate benefit agreements with affected Indigenous governments and organizations. This codifies industry best practices, as you heard in this room in a recent hearing. This is best practices that leading resource development companies already follow all over the world, including the majority of proponents in the NWT. Benefit agreement requirements are ultimately beneficial for all parties and a part of becoming a world-class jurisdiction in mineral resource development. At the same time, subsection 52(3) reflects the balance necessary to respond to competing interests by providing a limited exception to the benefit agreement requirement. You heard comments about this section in your previous hearings. This is a section that allows the minister to waive the requirement in exceptional circumstances. These circumstances are subject to many checks and balances, including administrative law, natural justice, and the honor of the Crown. It's not just the minister's right alone to do this. The minister must do this on the recommendation of the entire cabinet to take that step. This was a flexible and proportionate compromise that Clinchon Government and other Indigenous government organizations helped to develop and expressly supported through the development of Bill 34. As we've already said, changes to, or indeed the omission of Part 5 of this bill will provide serious concerns for the Cleacho and may result in withdrawal of our support. We strongly recommend that the committee respect the negotiation made by both public and Indigenous governments in the development of this bill. Looking ahead, Clinchon Government encourages the inclusion of express provisions in the Act that mandates consultation and co-drafting on the regulations that will fall out of this Act, that will cover off many of the important details of this regime, and any future amendments once the bills become law. This is particularly important on this bill because it requires many important issues be dealt with within the regulations. This is a place where, while negotiating and while discussing this bill, we felt was the best place collectively to put these issues. We've worked in partnership with GNWT to create these bills, and that partnership and collaboration needs to continue. There are express promises of engagement around new laws and new regulations in both the Clinchon Agreement and the Intergovernmental Agreement. Those commitments should be set forth explicitly in the acts themselves. This is consistent with sections of other acts already in place. For example, there are sections of the Mackenzie Valley Resource Management Act that explicitly requires the consultation of the minister in developing regulations, or indeed of the government when proposing any changes to that act. That concludes the sort of technical comments on the bill, and with that I'll leave it to the chair to allow Grand Chief the closing comments.
Thank you, Mr. Nevitt. Thank you very much for sharing your comments and your concerns on behalf of the Cleacho government. And without further ado, Grand Chief, I'll turn it over to you.
Yeah. I thank the committee for the opportunity to make these submissions about our work with GNWT on the bill. The bill is a crucial step in the devolution of jurisdiction over lands and resources in the Northwest Territories. The bills present an opportunity to create truly made in the North legislation that reflects the unique circumstances of our territories and the unique government relationship that exists here, particularly our treaty relationships. All northern governments have the responsibility to manage our resources carefully within our jurisdictions. We also have the responsibility to work together to manage the many resources we share. When we each pass our own laws that impacts our shared resources, we must do so in accordance with our treaty relationship. Our primary concern as a treaty partner is that the spirit intent of the Clincho Agreement is fulfilled through the bills. We have worked closely with the GNWT through the working group and intergovernmental council process to ensure that the draft bills respect and enforces the commitment and relationships enshrined in the Clincho Agreement. Under these circumstances, and with the important piece of this bill that we have spoken about left intact, we support both the legislation development process and that was followed and the bills that were produced. We look forward to working with GNWT as our own treaty partner, only further improve both government-to-government process and our vital resources legislations in the future. Merci for listening.
Thank you very much, Grand Chief. Appreciate you sharing your comments with us today. I'll turn it over to committee now for any comments or questions. First, I'll start with Mr. Testart.
Thank you, Mr. Chair, and thank you very much to the Calicho leadership for presenting today. You spoke about Part 5, and this is an issue that I have carefully considered in my own read of the legislation. And I appreciate that you're providing some more clarity on what the intentions, the policy intentions around benefit agreements in particular are. And you have told us today that it is around codifying best practice for industry. That is not clear to me from the way the bill is currently worded, and several other witnesses who have appeared before the committee, including co-drafters, have also offered different interpretations. So I guess my question is, if there were amendments brought to Part 5 and the provisions therein to clarify that this benefit agreements are in fact designed to represent industry best practice, would that alter your support for the bill? Thank you, Mr. Chair.
Mr. Nevitt? That's a more technical
Yep.
question. That's why I'm
That's
going
okay
to
for me.
Mr. Nevitt.
Thank you for the question. Yes, there has been a number of different perspectives brought forward, but I think one of the common themes was always that Part 5 was one of the fundamental pieces of this bill for all of us. There was some fine-tuning that may need to be done, or some of the groups brought forward, but without Part 5 as a major constituent of this act, it really wasn't achieving one of the key policy pieces that it needed, which was to, as we say, codify into the legislation what is best practice. The hearing you heard before in this room, you heard some discussions on the difference between impact and benefit agreements, and that this piece of legislation just deals with benefit agreements. And that was really because this is a Minerals Resources Act to develop and manage those resources, but also because the impact side of it is also dealt with in other acts. You have the Mackenzie Valley Resource Management Act that deals with impacts to the environment, to the land, to the wildlife, to communities, and that this was to provide for benefits to those communities. But at the end of the day, is it likely that a negotiation is going to be separate? Is it going to probably be a different negotiation that would happen under an impact and benefit agreement, which are actually required under treaty for the Clinchon government? Likely not. We're probably not going to end up with a series of different agreements. What we're going to end up with is an agreement that satisfies this requirement, but it's codified, and it satisfies any other requirements that are based in any other regulatory or authority that is developed either through our treaty requirement or through that through any measure, for example, from a review board. But the idea is that it's captured within this act and recognized as something that must be done. It's very much the department's position that it was a benefit agreement and not an impact and benefit agreement. That's just because of the jurisdiction that they feel they have. They don't have the jurisdiction to wade into the impact side of it. But at the end of the day, there would be benefits and impacts would be covered off through the, as we say, the complete system that we're putting into place. And without a complete system of regulatory management and benefit allowance, then there'll be gaps. And that's what we're trying to achieve here.
Thank you. Further, Mr. Testart?
Thank you. So, given that, and that's helpful, thank you for that, if the language was changed to impact benefit agreement, or if more clarity was brought to exactly this point, that it's the standardized practice, would that be problematic, I guess, for your perspective, for the perspective of the Tlicho government as a co-drafter and as someone who is standing in support of the bill? Because my concern, right, is when I hear, industry stakeholders, some Indigenous government stakeholders, members of civil society come forward and say, we're not really sure how this is going to work. And the minister who sponsored the bill says benefit agreements are a new world-class leading-edge policy tool that are different than anything we've seen before and are going to result in better results for Indigenous nations and for Northerners. So I'm confused too with that language, right? If the policy statement that came along with the MRA was, look, we're codifying best practice, that's all this is, but that's not what we heard from the minister. The minister said this is a new thing. So I think it's imperative that this be clarified so there is certainty. I think that's why we heard in the last hearing that you referred to, the Chamber of Mines say this should be pulled off and studied further because there's still a lot of uncertainty. And my interest in particular with this bill is clarifying that uncertainty in a way that works for everyone. So if there's any way you can provide, advice on how we can do that without altering the substance of what the Tlicho government's intention was in putting their ideas forward, that would be helpful. Thank you.
Thank you. Mr. Nevitt?
Okay. Thank you for the follow-up. To the point of impacts and benefits, right up front, our discussion was on that very frame of an agreement that covers off that, but it was, again, the department that said this is really the mandate that we have is to look at benefits. So would we object to the use of the word impacts in there? No, I don't think that would be an issue at all for us, but it's really now down to jurisdictions within your departments and a discussion for there. In terms of codifying more specific issues, and this has come up, I think, in a number of areas of the Act, and the committee members have asked questions that have sort of probed this issue a little bit before. The Act was designed deliberately, and this is really a sort of a choice that we made through the process to pick out all the key things that we wanted to see. We have to see engagement on claims. Grand Chief said to me, we never want to see a White Beach Point situation happen again. There must always be some form of engagement on new claims going in so that we are well aware of what is going on within areas of importance to the Clincho. So that was one, we call them the coat hangers almost. What are the key coat hangers that we needed to bring into this Act? So that was one. Another was the benefit agreements. So we made sure through the language that's in Part 5 right now, the benefit agreements are required, that there's a process mechanism set up. There are what we call the off-ramps. If Indigenous groups, including the Clean-Sean government, decided, no, we actually don't need to have an impact benefit or a benefit agreement for this project, I can't think of a situation there where that might arise, but it allowed for that off-ramp if we needed it. So was everything covered off in detail in this sort of codification that we talk about? No, but that's why we'd like to move towards the regulations and use those to detail what it is we want to see in benefit agreements, in the engagement process moving forward. So that's why getting that sort of detail in the regulations is important to us, and that's why us being involved, again, in the same way as we have been for the MRA in the regulation development is critical as well, so that we can see how these things will be negotiated through and be suitable for all of us. I think one further comment, though, on the benefit agreements is benefit agreements are evolving. They are evolving based on status of claims. They're evolving based on current best practices. So when we codify it, we're codifying the need. We're codifying the exact, they have to be put in, we need to have them. It's a best practice that impact and benefit agreements are always required. What the detail of all that is, and that's why regulations are often a better place to put it, because they're much more versatile. They can change, they can be moved along as things happen, as opposed to the detail that has to be done. It's the same with resource royalties, etc. You know, there's ability to move these things on within regulations that's not always there within legislation. So that's why we're suggesting that that's the most appropriate place to put these pieces of codification in. Okay.
Thank you. Appreciate that. Next, I have Mr. Simpson.
Thank you. Thank you to the presenters. There are some major things being moved to the regulations, and I just have some questions. We were at the table during these negotiations, and so I'd like to know what your view is on some of these. So Section 52 states that a holder of a mineral lease shall enter into an agreement for benefits when required in accordance with regulations. Now, was there discussions about when that would be? Is that prior to production? Is that sometime within the first year of production? Because that's one of the outstanding questions. So can the witnesses offer any insight on that? Thanks.
Thank you.
If you could give me 1 second, I'd like to just confer on this one quickly. Thank you for the question. I think you're asking about when the negotiation would happen, as opposed to when the development of the regulations would happen. Is that correct? I just want to make sure I'm answering the right question.
Thank you, Mr. Nevitt.
Yeah,
Clarification, Mr. Simpson.
thank you. Yeah, the Act states that the holder of the lease shall enter into an agreement for benefits when prescribed by the regulations. So I'm sure there was some discussion, not about when the regulations would be developed, when the regulations would require an agreement to be entered into. And I'd just like to know, was the discussion that the agreement would be required prior to production, or was there any discussion at all, I guess, about a date? Thank you.
Thank you. Mr. Nevitt.
Thank you for that clarification. Yeah, I think the intent will certainly be that we're looking at something pre-production, but again, it's something that would be worked out through the regulation development. So those timelines plus any of the requirements will be set out through that process, which we've said we need to be involved in the development of. So if it's not detailed in the Act, it means it's an ongoing discussion that we'd like to carry on. ITI has been forthcoming with terms of reference for the next stage in terms of regulatory development, but we would like to see that codified also into the into the Act itself to require that discussion.
Thank you. Further, Mr. Simpson?
Thank you. And I appreciate that, and I know that I understand the importance of the co-drafting process, but I also recognize that as a representative of the public, we have a role as well in overseeing the government and overseeing the drafting of laws. And so my concern is that there's so little in this act in terms and so much left to the regulations. Although I do completely see the need for this section. My final question is in relation to Section 53, and it talks about changing an agreement if there's a material change to a production project. And now this could go either way. I mean, if there's a sharp decrease in production, then the benefit agreement might change to the detriment of the Indigenous government. Or it could go the other way. There's nothing here about timelines, though. So in Section 53, it says there must, or the agreement shall be amended if there's a change of production. Is it your thought that if there's not an agreement within a certain amount of time, that would halt production? I'm not sure what would happen if there's a change in production, but there's not a change in the agreement. Can you offer any insight on that? Thank you.
Thank you. Mr. Nevitt?
I think the Clincho have quite a lot of experience on this situation. We've seen this happen already. We've seen it happen with existing IBAs at the mine sites, and it's definitely something that we would want to see again, some description of the process. But again, it's the sorts of things that we've asked to be put into the regulations for process there. Whether it require a mine to shut down if there isn't a renegotiation of an IBA, I would have to do a little bit of consulting and deferring on a position like that. But I know that in our discussions, it was left to part of that regulatory development that we want to be a part of. So I'll leave it there.
Thank you. Anything further, Mr. Simpson?
No, thank you for the answers. And these are some of the big questions that people are asking, so I just wanted to get your take on it, and I appreciate your responses. Thank you very much.
Thank you. Next, I have Mr. O'Reilly.
Thanks, Mr. Chair. So I'm looking at Chapter 23 of the Clecho Agreement, which covers subsurface resources. And, of course, there's requirements in there for any major mining project over $50 million or 50 people, or 50 people on site to consult with the Clecho government and hopefully reach an agreement that covers things like environmental impact, impacts on wildlife harvesting, location of the camp, maintenance of public order, employment of Clecho citizens, business opportunities, and so on and so forth. So I take it from what you've said that, and of course, these bills cannot take away in any way from what's already been negotiated in the agreements, but that those provisions of the Clecho agreement are consistent with what's found in Part 5. Can I just get that confirmed? Thanks, Mr. Chair.
Thank you. Mr. Nevitt.
Yes, and again, this goes to the very intent of the process that we've just been through. When we came into this, there were sort of two schools of thought, really. Some where we've got to defend, and there are others that said we have to integrate. And really our position as we move forward into developing these pieces of legislation, not just this one, but the Protected Areas Act, and you heard our comments on that, integrate renewable resource boards into the Act, integrate these processes. It's the same with this piece of legislation. We're looking to integrate the requirements of the Clincho Agreement into the Mineral Resources Act, and that's exactly what you see with the benefit agreement provisions. Without that, this piece of legislation is again outside of what's the framework of the Clincho Agreement and as we've said, doesn't necessarily have the support of Clincho and government. So does it satisfy it by itself? No. We're working with the federal government as well on a mechanism to ensure it's fully implemented, but does it integrate that spirit and intent into the GNWT's Act? Absolutely.
Thank you. Further, Mr. O'Reilly?
Thanks, Mr. Chair. So would this make it any clearer if there was a reference in the bill to saying something, and I'm not a lawyer, so something along the lines of, the requirements of Section 52 would be met if there's an agreement reached pursuant to Chapter 23 of the Tlicho Agreement. Thanks, Mr. Chair. And the reason why I ask that is there's some confusion around the difference between what's in Section 51, what's in Section 52, and then what's been negotiated in the individual agreements. So just to reiterate, if there was some language in Section 52 that says that an agreement reached pursuant to Chapter 23, I think, of the Tlicho Agreement would meet the requirements of Section 52 of the bill. Thanks, Mr. Chair.
Thank you. Mr. Nevitt?
Thank you. The 2341 requires the negotiation towards an impact and benefit agreement. This requires benefit agreements to be negotiated, to be completed unless the minister says otherwise. I think there's slightly different sort of ways of wording that. So I wouldn't necessarily want to require something. 2341's a little different in that sense. This requires benefit agreement. That requires negotiations towards. So I would suggest that that I'm not sure that sort of language necessarily needs to be there. I think I would point to the beginning sections of almost all these acts that basically speak to the requirement to be consistent with the treaties, which includes both the historic and the modern treaty agreements. So I'm not. So I think that already sort of requires that kind of. If something is done through there, then it may satisfy that. But I'm not sure we would. I'd have to have a look at that and get back to the committee if you want. But if timeframes allow. But I'm not sure I could commit to say we'd need a clause like that separately.
Thank you. Anything further, Mr. O'Reilly?
Yeah, thanks. No, I think that's helpful, and I'll just let the.
Sorry.
No, that's all right. No, it's a highly technical legal question, and if you have any further thoughts on that, I would invite them. And it's partly about trying to make this more understandable to members of the public, because some people, I think, have misinterpreted or don't understand what this is all about. So I want to ask, though, specifically about this idea of exceptional circumstances, the waiver that you referenced in 52.3. Surely to goodness there must have been some discussion of what that meant in the technical working group. Can you offer any insights into what exceptional circumstances really means? It's obviously not the usual practice, but what would drive a minister to say that a major mining project doesn't require a benefit agreement? I'm trying to understand why that's here and whether there was any discussion of specific cases or circumstances that might use that, or where that would be invoked by the minister. Thanks, Mr. Chair.
Thank you. Mr. Nevitt?
Okay. If you could give me a second, I'd just like to consult on that one as well.
Thank you. Mr. Nevitt?
Thank you. There was a lot of discussion about this clause at the table for sure, and that was what partly led it to the requirement, not just for the minister. There was discussion around whether it could just be the minister by themselves. And this is what led us to that idea of it's not just the minister that gets to do this, it's the minister on the recommendation of cabinet. And cabinet is there, of course, and they sit there and they have various departments. They have ENR, they have executive, they have, there are multiple departments, and that's the idea around creating a scenario where it's not just one person, It's not just one person being able to, sit there and decide, oh, well, I think this mine should go ahead. It's got to be a cabinet decision. So I think the process thing is very important to note, and, exceptional circumstances, as we said in our comments there, they go around the laws of duty to consult, around the laws of administrative law, of natural fairness, of issues like that. If the minister makes a decision based on cabinet recommendation that really doesn't seem necessary, we don't want to end up in the courts, but of course that's what may happen. In terms of exact scenarios of what could be done here, we didn't have detailed discussions. We've had more of the internal discussions that talk about, well, we live in a jurisdiction with multiple and overlapping claims in places, some of them defined and some of them not. So in some places we have scenarios where we have Indigenous communities and Indigenous groups with undefined jurisdictions, and so there are places where people might be pushing and asserting for certain things that need a decision at the end of the day, and that may be if you've got a mine that's got settled agreements with 5 Indigenous groups and another one suddenly comes along and the minister decides, okay, well, I don't know whether that's appropriate based on the advice of my committee and based on my requirement to consult and to ask everybody around me and the people that I should be asking if this is correct, whether that's correct. So that's the sort of exceptional circumstance that was being considered. And I think that, as we know, in any sort of deliberation and decision, there's always mechanisms to either challenge that or to talk about that. And we always considered that the route through that.
Thank you. Further, Mr. O'Reilly.
Thanks, Mr. Chair. I find that really helpful, and I want to thank Mr. Nevitt for that. The last question I've got, at least for this right now, is Section 52 uses the words of a production project. It's not defined anywhere in the bill. And when we were, production is defined in here, but production project is not. And for a mineral property, I guess, to go into production, it's going to require a production license. So I was just kind of surprised that production license is not used in this section, that basically you have to have a production license, or if you want to get a production license, that requires a Section 52 agreement. Was there any discussion of this production project, whether there should be a definition for it or how it ties in with a production license? Thanks, Mr. Chair.
Thank you. Mr. Nevitt.
Thank you. I'm just looking it up here. I don't recall, to be honest, any specific discussion on a definition for production project.
Thank you. Nothing further? Next I have Mr. Nakamayak.
Thank you. Thanks for your presentations. And the questions are actually really good. Coming from a land claims myself, and looking at impact benefit agreements for oil and gas, and and mining and other types of projects and other types of developing IIBAs. I'm very familiar with that in the Inuit world, and some of these are on water that are jurisdictional over the government of Canada, and some of them international waters. I think whatever mechanisms are in place, you're right by looking at looking at the terms and focusing on those for the Indigenous groups. What I worry about sometimes is say if as Mr. Simpson mentioned earlier, if production goes on and there's negotiations, pre-negotiations, I'm just worried about possible environmental issues that may affect the projects that are being planned, and at the end of some days could cost the Cleacho government or the IRC or SSI or Indigenous groups that have these plans with the mines and with Canada and with the GNWT into jeopardy, and slow things down and put the risk back into where, okay, is this mine feasible or are the plans feasible going ahead or not, or are the asks of the Indigenous people or the governments realistic or unrealistic? We have to think about all of those factors when we start to plan and be realistic. And I think you, as a Cleacho, with the planning with your all-season road and having access to the areas that you have, could really drive the whole process yourself and take more control of this than you already have, in a good way, to help your people thrive and to set examples. There's a lot of groundbreaking work that's going on as we speak right now with your government and the work that you're doing in the planning, the projects. Everybody's learning from it. The government's learning, the territorial, the federal, other indigenous governments, and other non-signed claims are learning from this. So I think you have an opportunity to utilize this time to really drive this policy into how you see fit, and also it may make you bring on more people to say, okay, well, is this going to really work in the inner workings of the Cleacho government, so that these bills and these laws that are moving forward are workable within your organizations. I think now is probably a key time to start thinking that way, on to the next steps. Getting back to IBAs, I know those are private and confidential between yourselves and any government that you negotiate them with, and I think they should remain that way. And myself having the big potential with LNG in my region, I think those should remain confidential, so that gives the indigenous governments a little bit of room and margin to work, with the resources that they have, and so they could extract them responsibly and for the benefit of their people as well too. Looking at overlap of some of these may fall into other laws that are being other acts that we sit that the GNWT has coming forward. So I think we need to tread a little bit. I wouldn't say lightly, but just pay attention to the really fine print and ensure that and it seems that you have that down pat. To ensure that we're not putting our governments or your government into a situation that may not be favorable to you. What was I going to get back to earlier? There was a couple of things as I was listening. Back to developing policies together. There's a point where we'll have to latch off from the indigenous government, but it seems that you're driving the best interests of a lot of indigenous governments who we have a lot of land, we have a lot of treaties, and we have a lot of land claims across the territory that the government and other industry may have interest in, and they do. I think we really need to push that to our advantage, so that the land claims and the treaties is not only yours, but it also belongs to the federal government and the territorial government. So I think your outreach to whatever department that you have is probably stronger than you think it is, with the support of committees like ours, and and being from land claims ourselves too. I see the importance of what we need to do to ensure that you're actually pushing in the right direction. Other examples, there's really not many other examples other than some of the work that's been going on in Satu and that. So I think it's a good opportunity to really design this how you see fit. It might be worth walking down the hall to ensure that you're drafting with the government on this to push forward. I had a couple of other things here, but if I may, Mr. Chair, I'll just hold off until after. But right now, that's kind of what I had on my mind. So thank you.
Thank you. Take that as a comment for the record, not necessarily a question. Any reply with regard to the comment? Grand Chief Mackenzie.
Yeah, I appreciate your comment that you made about the IBA and everything that goes with it. We talked about the White Beach Point activities to be. I asked one of the elders, what do you think about all this that's happening? He said, in a nutshell, he says, it's like this, he said. If somebody goes to your tent and you're not there and takes things from your tent that you needed, and then it would offend you, he said. But somebody goes inside your tent and asks for permission, we will definitely share it. So we'll grant the permission. We will not deny the permission. And this is how you put it in a nutshell for everything that we're talking about. I just want to make that comment.
Thank you, Grand Chief. Next I have Mr. McNeely.
Thank you, Mr. Chair, and thanks for your presentation. I find it very similar to the SATU agreement in chapters 22 and 23 on the process to create certainty and participation and the phase for negotiating benefits. A very similar presentation was made by another group on May the 8th here in this room, agreeing with what you're saying on part 5 and the technical group's discussions clarifying the difference between the impact and the BA and where do they come from. So keeping that in mind and keeping in mind on the chapters 22 and 23 of the SATU claim, which is very similar to yours, uncertainty and control. I can really understand your presentation to ensure that there's certainty in Bill 34 to comply with what your presentation has stated. So I hear that. Thank you.
Thank you. More of a comment? Comment noted. Further, Mr. McNeely?
I just forgot to add here, I hope we're not going down the same road as your actions to the federal Bill 48, so that we don't sit at the same table again. We want to get it right, and I think we all know what happened to the federal Bill 48. Now it just wasted a bunch of time because you corrected the hand that signed off on something that was wrong. So in my view, when I look back at 48, it was just basically a waste of time. And now we're having to deal with it all over federally. Thank you.
Thank you. Comment noted. Further comments, questions from committee? Mr. O'Reilly.
Thanks, Mr. Chair. I just wanted to make sure that before anybody went away that you didn't get the impression that I don't support what's in Section 52. I do. That the idea of having a benefit agreement, some kind of an arrangement with adjacent communities for major mining projects, that's a bottom line for me as well. So I did, though, have a specific question about the regulation making an amendment process. I think I heard in the presentation that you want explicit requirement written right into the act that the Tlicho government, at least, perhaps other Indigenous governments, would have the right to be consulted in the drafting of regulations, any changes made to the Mineral Resources Act if it's adopted into the future. So you want explicit language right in the bill itself, just to confirm that. Thanks, Mr. Chair.
Thank you. Mr. Nevitt?
Yes, that's the intention, and we've asked for that actually consistently through all the pieces of legislation that have been brought forward, or we would suggest it be there for all of them. It's a term that's been used. There is precedent for it. There's language within the Mackenzie Valley Resource Management Act that requires that for any regulation development or amendments to the Act. So if you wish, we can provide that language, or you've got staff who can look it up, but we can do that for you as well. But there is language in existence for that, to set that precedent.
Thank you. Further, Mr. O'Reilly.
Yeah, thanks, Mr. Chair. Yeah, there's 1, 2, 3, 4, 5, 6, at least 5, no, maybe 5.5 pages of regulation making authority in this bill. I've never seen that much in any other bill that I've seen come through here, at least in the 18th Assembly. That's a lot of authority in the hands of one minister, in my view, too much. But if you have specific language and want to talk about where it would be inserted into the bill, I think that would be very helpful for the committee to have that language and to know where you would like to see it incorporated in the bill. So if you guys want to give us something in that regard, I'd appreciate it very much. But thanks again for your time today.
Thank you. Comment noted. Next, I have Mr. Testart.
Thank you, Mr. Chair. So just further to my colleague's questioning on that, but you mentioned that the MVRMA was an example. Do you feel that that provision would be sufficient to address these concerns? I can't remember the exact wording, but I think it's something along the lines the minister shall consult with First Nations, I think is the language in the MVRMA. But would that be a sufficient clause to address these concerns and at least open the door for further collaboration on regulations? Thank you.
Thank you. Mr. Nevitt?
I think it's a part of it. I think the ongoing good governance that the GNWT has shown in working with the departments, working with Indigenous groups to do this development of both the legislation and any falling out regulations to date needs to continue. The department, ITI, has already issued draft terms of reference for that process moving forward. So we've got example, but codifying it into the legislation again, I think would be important. It's embedded within the intergovernmental agreement as a requirement that we work together and we consult and in development of these regulations. And it's a requirement of the treaty as well. It's in the Clincho agreement that any legislation will be consulted. So I think it's best practices that's being done again. We went back to the issue of best practices. It's just an example of how we like to forget that actually the NWT is so far ahead on many of these things than anywhere else, that we're actually doing a very good job, and it's just a matter of, it's a good way to promote ourselves. It's a good way to say we are doing a good job of consulting and engaging between our respective governments as we move forward on developing these things. So why not shout about it within our legislation?
Think further, Mr. Testar?
Yeah, thank you for that. And I think that's part of it. There's only so much we can legislate. Some things have to be public policy decisions that governments make and commitments that governments live up to. So I don't want to be too prescriptive in how far we reach into the regulation making side, but I do think it's necessary that we put in a provision like that, and that a provision like that be present in all of the devolution legislation that's before the committee, and that will be before future governments as well. And I think we can work as a committee to develop those kind of changes and also develop those recommendations for government. And I think this is a perfect example of how reconciliation can work and be successfully achieved if we work together and all parties have a seat at the table. So I thank you for the work you've done on this piece of legislation, and I can assure you that I don't view the role of this committee as changing the substance of the bill. I see it as ensuring that the public's interest is taken care of in addition to the interests of the individual governments who co-drafted the bill. And I think with this piece of legislation in particular, we're much farther ahead to that point than some of the other bills we're working on. So thank you again for your very thoughtful commentary and helping us better understand some of the policy decisions behind the MRA. Thank you.
Thank you. Comment noted. If there's nothing further from committee, Grand Chief Mackenzie, would you have any closing comments?
Yeah, just a quick one. I know everybody's busy. We have to get back to our next meeting. And I thank you, the committee, for meeting us again. And I just want to wish you luck in the election. Thank you.
Thank you, Grand Chief, and thank you to you and all of the chiefs that have joined you today and your representatives from the Clecho government. On behalf of committee, we want to thank you for coming again all this way. We regret that we didn't have the opportunity to get together a little bit sooner. And just to let you know again that when we make our report in the upcoming sitting of the Legislative Assembly, then we'll be for sure taking what we've heard from you today and incorporating a lot of that into our report. If there is, I think there might have been one or two commitments to send us some additional information. So, Mr. Nevitt, if that can be done in a reasonably quick time, that would be appreciated. And if there's nothing further, then thank you all once again, and we can be adjourned. Thank you.